to this episode of Real World Contracts Law. We are here in the BLC Digital Studio once again. I'm Elizabeth Payne-Maddalena here at Berenzweig, Leonard. I'm a senior associate who handles a lot of our litigation matters, as well as joined here today by Rachel Goodnight. Rachel, if you want to introduce yourself.
Hi, I'm Rachel Goodnight. I am the marketing manager here at Berenzweig, Leonard, and I'm excited to be in the studio with you again, Liz.
I am just as excited to be back with you once again also. So I know today we're going to be talking a little bit about what some of the things that we have seen in our years practicing that come up in contracts cases, particularly when cases, reach the stage of lawsuits and litigation, but some of the stuff that particularly comes up before that time that we just thought would be helpful to talk about to people for them to keep in mind. Of course, this isn't legal advice in any way, but just something so people have a little bit of an understanding and might have some ideas on what to do if they ever find themselves in some sort of situation where there could be or is a contract dispute.
Right, and it seems like before something reaches the full-blown level of like needing to go to court and things like that happening, there are proactive steps that people involved in contract disputes, breach of contract matters can take to protect themselves and set themselves up for success early on in the contract relationship.
Yeah, that's exactly right. And also, these are steps that people can take to hopefully avoid having to go to court at all.
The ideal situation.
Right, because nobody wants to have a lawsuit. I mean, nobody does. I'm a lawyer and I understand that. People don't like it when I show up at their door. So these are all things that you can do, and they're actually things that, are pretty simple and straightforward as long as you're just keeping those things in mind. So, and I think the first thing is that, the biggest thing that everyone should always remember is when you are signing an agreement, entering into a contract, keep copies of that. Make sure you have the copy that you signed, the copy that they signed, any emails that are just confirming receipt or discussing any potential or actual changes. Keep all of those. Do not delete them. Those are going to be so important. You're going to hear us reference the contract so many times during our podcast today. And trust me, you're going to be that is something that you always, always, always want to do in every single contract, every single relationship.
Especially today when so many things are signed digitally and it can happen so automatically, it can be hard to remember, like, hey, make sure you have this in your email. Or if you're a paper person, print it out, put it in a cabinet, just know where it is and know what you've signed.
Right, that's also important. And then also always make backups of things because things can get deleted. I always, email is great, but if you keep it in your email, something happens and it accidentally gets deleted or lost, then you're in a really bad situation. It's going to be hard for you to read that contract to see what you need to do if you can't find it. So that's the other thing I always recommend is if you're a paper person, keep extra copies somewhere. Just make sure you have copies saved.
Anyone who's been in my office knows that I'm a paper person, so I am a big fan of that.
Yes.
So let's say that you've got the contract, you've got your copy, you've signed it, you start going, and then something doesn't feel right. Something, maybe you can't put a finger on it, maybe it's just a gut feeling, but something feels off between you and this person or this company that you have started this contract with. What do you do then?
That's a great question because oftentimes, especially if you've maybe been doing business for a while or you're a little familiar with this, you'll just kind of get a sense like something doesn't seem right here. Mm-hmm. And it's important that the moment that you start feeling like something is off or that things start to go wrong, you want to start documenting that. Documentation is so important. And I think people think documenting is what exactly does that mean? I mean, do I need to shoot off an email? But I'm talking about things as simple as if you have a phone call with the other side to talk through an issue or talk through some questions, shoot them an email just saying, hey, just want to confirm that this is what we talked about today. It doesn't have to be to anything in depth, although I will recommend always make sure these emails are polite. These are it's a good way to get yourself in trouble is people, emotions run high, understandably. Sometimes people want to get off of a call and say, just want to confirm our discussion today that you're an idiot. don't send that email. Remove the "you're an idiot" part. That looks so bad in front of a judge, and it really can come back to haunt you. Not to mention how it can impact the relationship too. But also making sure you're documenting any kinds of discrepancies that you're seeing. If you're at the point where things aren't being delivered as promised, it's when you're going to want to start taking photographs, documenting that too, and we'll get into that a little further. But documentation is really key, because what you're doing is you're starting to build up that case.
Supporting yourself
Yes.
should something happen in the future that you need to prove happened.
Yes, exactly.
And so let's say, you have that funky feeling, you're documenting things. Is there something that you can do before you reach the level of taking it to court that you can do to start maybe trying to rectify the situation with the person you have the contract with? Like, are there steps you're supposed to take first before they go to that level?
Not necessarily that you're supposed to take first, but these are smart and business savvy things to do. And the most important thing is when something goes wrong, when you get a shipment of non-conforming goods, when people are not delivering as is required in the contract, you will need to take action at that point. And I don't necessarily mean legal action. This is when you want to try to resolve things. And how do you try to resolve things? Well, that's where your contract's going to come in really handily. This is going to be a guidebook, because there are going to be, or there will likely be, provisions in your contract that says this is how you have to notify them of non-compliant good, of a defective delivery, of this is how long you have before you have to, or how long you have before you can reject, or how long you have to reject, and what the process is going to be there. Look at your contract carefully and read through that. And another thing that's really important when it comes to these notices is make sure they are in writing. Always, 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 always put them in writing. Your contract may not require that they're in writing. Put them in writing, because it is so much easier when you have an email or a letter that was sent saying, hey, we received your shipment of this stuff, and they were supposed to be green, you sent them in red, and all of these things that are defective or non-conforming. And having that in a letter where we can see when it was sent, or an email where we can see when it was sent, versus someone getting up on the stand and testifying, because then it becomes a he said, she said, or she said kind of situation. And those are much harder to prove. So always putting that stuff in writing is going to be hugely helpful. And again, also, this is where you get into that documenting that I talk about in the other way. The photographs. Rachel loves this. She's a photo person.
I am.
You definitely want to, if you're getting shipments of things that don't look right, taking photos, making sure you're keeping track of when you're sending things out, how long you have, when you receive things, when you're sending out like these notices, any complaints you're getting from customers about it, or from other people who you might be obligated to that are affected by these issues. You just want to keep a record of all of this, because again, you are creating support so that if this does go to court, you do have evidence that supports you. And also, frankly, being prepared can help with resolving these things, because if they see that you're taking these things seriously, they're going to be more willing to hopefully resolve these things.
Absolutely. That would be the best case scenario if things go wrong, to be like, hey, here's all the things that happened. And then they're like, oh, whoops. Maybe they didn't realize how persistent the problem is, and the opportunity to fix it actually will lead to resolution. If not, then we take it a step further.
Right.
So with all of these things that people can do, I think it might be helpful to put it in a little context.
Yes.
So let's run through an example scenario. Let's say you're a keyboard manufacturer, and you have a contract for someone to supply switches for your keyboards. Everything's going well, you've been happy with the product, and then one day a box arrives and everything inside is damaged. It doesn't work, it doesn't fit, it is not what you signed up for. What do you do?
Great question, and I think this is a great example. The first thing you're going to do is start documenting immediately. When that box gets opened up and you get the call, or from your mail room or from the warehouse, where they go, hey, this doesn't look right, and everything is really there's a lot of damaged equipment in here. They sent us the wrong switches, the wrong sides. Tell them, hey, we need you to take photographs. Can you count how many of them are defective? How many are the wrong side? Just keeping those kinds of records, because again, you're showing the number of defects here and the kinds of defects that need to be corrected. And then the next thing that you'll want to do is read your contract. See what it says about what to do about defective or non-conforming shipments. How long do you have to reject? Make sure you are rejecting within that time frame. Oftentimes these agreements will say things like, if you don't reject or object within 15 days of receipt of the shipment, you've been deemed to accept and you have to pay for it. You don't want to end up in that situation. So that's why you want to read it and then make sure that you are sending any notices in writing in that time period. And that notice should say, here's what we received, here's what the problems were, per the contract, we are requesting that you, and then whatever the contract says that the remedy should be, or, an acceptable and agreeable remedy to you if it doesn't say anything. So could be as easy as just send us a conforming replacement shipment within X amount of time. But you want to make it clear as to what you're demanding and asking for. And I think a lot of times at that point, especially if you're being reasonable, you're complying with the contract, hopefully they'll say, yeah, okay, that sounds reasonable. Here you go. Here's your conforming shipment. Here's the correction. And then if not, that's when you move forward to a elevated level of dispute resolution, as we'll call it. And the other thing that is important too is documenting any delays that this, could any delays on your business or effects on your business. So, keyboard manufacturer, right? If you have a big shipment of keyboards that are supposed to go out to a retailer or a reseller, and now you can't meet that, make sure you're documenting that. Make sure you're documenting what those effects are, how long there was a delay is, if you had to go out and purchase like an alternative good because they wouldn't be able to replace or repair in time. You want to make sure that you are keeping documentation on all of that, all of the costs that you're incurring, any lost costs, any losses, lost orders. Just make sure you're documenting all of that too, as that's going to be really important to have records from the time of. Again, especially if this does turn into something where you have to go into litigation.
That's that elevated level of dispute.
Yes, that is one of the elevated levels of dispute resolution. Yes.
Awesome. Thank you. Another scenario, which I am actually even more excited to talk about, because back in a previous position, I was involved in this on the other side, is event planning. A conference or a festival or something where you have vendors set up. You make agreements with all these vendors. They receive guarantees on spaces, which location they're going to have, coverage, rain out plans, electricity. So I've issued and coordinated hundreds of these several years ago, but it was a big deal and people needed to know what they were getting because they were, taking risks with their product. They were spending a lot of time. What happens if you are doing like a conference for videographers, graphic designers, and they're all coming? It's one of those big, like a tech conference, and you are guaranteed, a 10 by 20 spot, electricity, prime position, and then you show up and you get stuck in the basement. You don't have an outlet. You're not listed on the inventory. How do you handle a situation like that? Okay, so assuming that you've entered, like, let's say you're you've entered an agreement, a contract for the space. You paid for this space, and you've signed an agreement with the convention company, and they promised you, as you mentioned, a certain size of a space, like 10 by 20 or something like that. They've, said you'll be on the main convention floor, you'll get this signage, you'll be listed in the directories, you'll get tables and electricities, all the stuff that you're going to need, Wi-Fi probably in a modern day conference. Yeah. And then you get there, and nothing is as was promised. More like a shoebox.
Yeah, you're in a teeny tiny 10 by 10 space. You're stuck in the basement, I think you said.
Yeah.
A corner of the basement or something like that. So definitely not on the main floor. No signage. There's no one knows where to find you in this situation. maybe even, you've seen these situations before where suddenly, that electricity that was promised to you, well, it's a single outlet and it's you and like 10 other vendors have to duke it out and try to figure out how to all share this one outlet.
How many extension cords can we plug into this thing before we lose all power entirely?
Yeah, or before the fire marshal comes and says, "Oh my God, what are you doing?" That's one of those situations where, you are, as a business, you're going to want to try to make the best of the situation. But while you're doing that, again, this is where you start documenting. Obviously there you're not going to set up and just sit in a corner and read your contract. You're going to still try to, get the business that you're trying to do, make any sales or gain any potential customers that you wanted to do. But make sure you're taking photos of things. Make sure you're maybe doing a video, do a quick video of like, hey, this is our booth. This is what was promised to us. As you can see, this was not a 10 by 20. Hey, look, this is the power outlet that all of us are all sharing. It's weird. It smells a little like something's burning if you put your nose close to it. Not a great idea. Just again, you're documenting to show all of these discrepancies. And that can be very helpful, especially because a picture and a video, especially in today's world, speaks 1,000 words. So that's what I would do. And then, of course, once the conference was over is when you would read your contract to see what you need to do. And you would start going through, reaching out to the other side with demand letters and so on.
So at what point in a contract dispute or a breach of contract matter, when do you call a lawyer? When does it reach that level where you're like, I need to speak to a professional because that's the level of conflict we've reached?
So, I think that's a great question. And a lot of people are going to hear what I have to say and go, well, of course she's about to say, call us, the moment the dispute arises because she's a lawyer and she wants to make money and all of that. And the reality is, though, is that getting lawyers involved early on can actually end up saving people money in the long run. It sounds counterintuitive, but it is true because, getting a lawyer involved from the get-go can help you understand your agreement. So when that dispute arises, you definitely want to understand what you have to do. And look, I write contracts. I will tell you that they're not always the easiest thing to understand. Where a comma is and whether or not and or is used can actually make a difference. So having a lawyer involved can be helpful to at least just explain to you, hey, this is what the contract says, and this is what you need to do. And the lawyer can also help you with handling negotiations, talking about strategy. Oftentimes it may not be a situation where you necessarily need the lawyer to be handling all of those initial negotiations and discussions, but they can help you create a path forward to do that. And then, of course, once you get to the situation like that last scenario we talked about, you're in it is very obvious that they are not delivering what has been planned. That is when you definitely want to start reaching out to an attorney. And, the other thing that I think is important about knowing what the contract says is because of the way these things are written, and sometimes just because of the fact that, sometimes businesses are using contracts that don't apply to the situation or that don't apply to the state or city that you're in, or language that just doesn't apply in general. People will see terms in these agreements that say things like waiver, no liability, and it seems very scary because it's like, well, I don't think I can sue because it says there's no liability. But that doesn't always mean that you can't sue. It doesn't always mean what it looks like. And that's, again, where it's helpful to have an attorney because they can just tell you your rights. And knowing your rights is always the most important part of any kind of legal dispute. Understanding your rights, knowing what you can do, and knowing what paths you have forward.
Yes, having someone that can help you navigate that very specific terminology and help you determine your path forward. It's just something that can be super helpful, and like you said, before a contract arises, or a contract dispute arises, it can be more like a preventative measure, helping you make sure that the contract is fair from the get-go. And if you reach that level later on where help is needed or that elevated level of dispute, then having an attorney be there to help you see what paths are available to you. That's just something that is not always obvious from these contracts when you read through them, without that kind of legal eye to see what that means or have the knowledge of what is pertinent in this situation and not. Because when I look at that, because I'm not a lawyer, I see it and I'm like, ooh, wait, I don't know if I can do anything. This tells me I can't, and this is the contract, so that must be exactly what it means, as opposed to when you look at it and you're like, oh, that's not applicable here. That's for a different state. That doesn't carry weight here. There's so much insight that you can provide.
Right, and that's exactly what I think is important and helpful for having a lawyer involved. But for the parts that anyone can handle, the documentation. I mean, what your contracts oftentimes are calling for. What is supposed to be delivered to you, or what you agreed to when you bought that booth. If it doesn't look like what you agreed to, just start taking those photos, start taking those videos, start keeping track of losses, of potential losses, and just making sure you're documenting. And in the end, that will also give you a huge leg up if it does end up in litigation, because then you will have to, prove damages. You'd have to prove what the breach was, prove how things were not right, and having those photos, having those videos is really powerful, and having things in writing is really powerful, especially since litigation can take a while, and by the time you get on the stand, it could be 2 or 3 years after everything happened. And then you're trying to remember exactly when things happened 2 or 3 years ago. It's not easy to do.
And if you don't reach that level of conflict, or the performance of the contract levels out, or you're able to reach a resolution, you lose nothing by having that information on hand.
Right.
It costs you nothing to have it, just in case.
Right. It really doesn't. I mean, it's such a small amount of time. It's a blip on the radar. And oftentimes, again, if people see that you're taking this seriously, it may make them sit up straight and take it a little more seriously themselves. So, there's really it's a no-lose situation in my view.
I agree. Well, thank you so much, Liz, for joining me in the studio today. I think this is really great information, and there's a lot of proactive measures that can be taken to help people protect themselves and their businesses. Contracts are such a common thing, and I think sometimes people might forget to slow down and make sure that they're reading what they're signing and make sure that they're getting what they have been promised to get. And then if something goes wrong, there's some steps to take to help rectify that.
Right. And I hope that this has been helpful. Hopefully some people have some good takeaways that they can tuck in the back of their mind and hopefully never have to use. But we're always happy to help if anyone does have any questions or wants to reach out.